So you make an offer to purchase this house for a price. If people
Yes,
could
sir.
see this house, they would say, that's a lot of money, but that's a lot of house.
It is. Yes, sir.
So, all right, you make an offer, I'll buy it. Mr. Pianowski accepts it in good faith. Then after you make the offer, you realize, hey, I can't keep horses on here.
Centerville's Al MK house deal explodes immediately. Buyers Bittner demand their $5,000 earnest money. Seller Pianowski fires back with damages. Horses, acreage, zoning, and escrow confusion collide from the opening seconds. Stay locked in as facts unravel and expectations crash before judgment drops. Subscribe, like, share for drama.
All right, this has to do with a house that was for sale here in Centerville, which is known as the Al Merck House to people that live in Centerville. And Mr. Pianowski bought it, and the Bittners were interested in buying it. They put down a $5,000 security deposit or earnest money in escrow with their insurance agent. Mr. Pianowski, so they filed a claim for $7,000. Mr. Pianowski has filed a counterclaim where he claims $7,000 in counterclaim damages. In the meantime, this $5,000 has been sitting in escrow for more than a year. Mr. Bittner would like to have that earnest money returned to him. This has to do with the purchase of this house, and in part, there was an issue about whether plaintiffs could keep or maintain horses on this property, among other issues regarding the actual size of the parcel and some other issues. It was hard to track it all through the telephone text. But Mr. and Mrs. Bittner, this is a very fine home, maybe the finest home in Centerville. You were interested in purchasing it with the intention to keep and maintain horses there?
Eventually, yes, Your Honor.
All right, tell me about, first of all, I need to have everybody raise their right hand. Did I do this already?
Yes, sir, you did.
All right, I did. Everybody's been sworn. All right, then go ahead. You intended to buy this house and maintain horses and perhaps other things. So what was your intention in buying this home and moving to Centerville?
Yes, Your Honor. I have prepared a statement. Is it okay if I read from that to present our case?
Yes.
Thank you, sir. All right. Good afternoon, Your Honor. On behalf of my wife, Emily, and I, we would like to take a moment and thank you and the court for taking time today to consider our case. Emily and I never wanted it to come to this. All we ever asked at various times over the past 19 months is that our earnest money be returned to us in adherence to paragraph 27 on page 6 of the authorized buy and sell agreement, where it specifically states that the offer made is not accepted, or if the sale is not closed due to a failure to satisfy a contingency specified herein for a reason other than default of buyer, the earnest money shall be returned to the buyer. The defendant has continually denied signing the mutual release of buy and sell agreement, and therefore we feel as though we have no other recourse other than what has brought us here today. In early May of 2024, our family was living in the Dayton, Ohio area as I had just retired from the Air Force. Given that my wife and I are both from Elkhart County, we began looking to buy a house in the area so we could move back closer to friends and family. At the start of our process, we did not have an agent representing us, and I reached out to Berkshire Hathaway, the brokers representing the defendant, to see about showing a residence he had listed for sale at 598 Anthony Drive in Centerville. Mr. Joshua Nagy, the defendant's listing agent, was not available to show us the house, and Miss Mary Rosenberry agreed to show us the property. While we were touring the house, Miss Rosenberry informed us there was another 2 parcels available to purchase to go along with the parcel the residence was on, which was 6.26 acres. We had inquired as to how many additional acres there was, and she told us about the GIS database that shows all the parcels. When we pulled it up, she showed us how it works. It was identified that there was 2 additional parcels belonging to the defendant, one listed at 5.91 acres and the other at 1.32 acres, bringing the total available acreage for purchase to 13.49 acres. After the viewing of the defendant's—
All right, now let me stop you.
Yes, sir.
Some of this acreage is the house. There's
Correct.
a very large house and an outbuilding and a very large lawn. How
Yes,
much
sir.
acreage was the actual house?
That was on the 6.26 acreage lot, Your Honor.
All right. And there was an adjacent 5.91 acres potentially for sale and an additional 1.32 acres.
Correct. And that was directly across the street on Anthony Drive.
All right. Mr. Pianowski, do you agree with everything they're saying so far?
Yes.
All right, we're all on the same page, so go ahead.
Yes, sir. Thank you, Your Honor. After the viewing of the defendant's residence, Emily and I returned to Ohio with our 3 children and discussed what we wanted to do. At that time, we also decided to hire an agent that we had contacted previously after viewing houses in Middlebury. From that point, all contact we had was through our agent. Before submitting an offer, we were told that the property
All
fell
right,
just
Josh Nagy and Mary Rosenberry were the seller's agent. Who was your agent?
his name was Rich Carpenter with Bright Star Realtors.
All right, he's all over in the texts and emails.
Yes, sir.
All right, go ahead.
Okay. It fell within the village limits. Therefore, we believe there was a special conveyance that allowed the property horses, which was one thing my wife had wanted in a property. They weren't certain, but we would follow up and see if there was any formal notification of that. We also inquired about chickens and were told there were others in the area that had chickens without any issues. After Emily and I
All right, well,
discussed,
let me back up for a minute because horses is a large component of this. So you're looking for the house, and in this original showing or listing for Mr. Nagy, and I've looked at the pleadings, was there mention that it would be available for maintaining horses?
we were told that they believed there was a special conveyance for the horses, although it
Who
did
told you
reside
that?
within the village limits. Your Honor,
Who told you that?
this was not given to us originally when we viewed the house. It was later on after we had inquired. We had raised some questions to our realtor. We did make it known, I believe to Ms. Rosenberry, that we were interested in eventually having horses, but that it might be complicated because, as you know, it was the last property within the village limits of Centerville. And so then upon hiring our agent, then he ran it down a little bit more for us. And that's when they found out that there had been previously a special conveyance from the previous owner. I believe you said his name was Merck.
Yes. Mr. Pianowski, did you buy this from Al Merck, or was there a buyer in between there?
I bought it from Elmer.
All right, at one point, a doctor was gonna buy it. I don't remember what happened. That deal didn't go through, and so, all right, so you bought it from the original person that built it.
Yes, sir.
All right. All right, go ahead, Mr. Bittner.
Yes, sir. So after Emily and I had discussed, we decided to submit an offer through our agent for $670,000 that we between she and I broke down to giving him the full asking price of $599.9 for the house, and then $70,100 for the additional 7.3 acres of vacant property, roughly $10,000 an acre. The offer was written by our realtor, and Emily and I both signed the document on 16 May 2024, giving the defendant until 5 p.m. on 17 May to accept. He accepted the offer on 19 May 2024 at 9:15, as seen via
All right,
his
slow
digital
down.
signature. Yes, sir.
All right, so they accept your offer for the house and the land, $670,000. All right, then the clock starts to tick. So you make
sir.
an offer, they accept your offer, 8/19. What point do you put up the earnest money?
So on 21 May 2024, we made a $5,000 earnest payment that was deposited by the broker on 24 May.
All right. All right, continue.
On 22 May, I spoke with Doug Kuhlman, who works in the zoning department. We had a lengthy conversation about the special conveyance that was given to the previous owners. but that the approving board did not have the authority to do so, excuse me, and that the special conveyance was being revoked. He and I continued to talk about other alternatives, including us trying to buy connecting pieces of property by other individuals that we could then use for housing a barn and horses.
What was the problem?
What was the problem?
Yes, the house was in the city limits and the other land was outside the city limits, but it wasn't enough to keep horses.
No, sir. All the other parcels that Mr. Pianowski had offered for sale were actually north of the parcel that the house was on. Therefore, those were still within the village limits of Centerville.
All right.
And he said that the board, upon further review, did not have the authority to approve that special conveyance, and therefore he had sent a revocation letter concerning that. But however, it was sent to Mr. Merck and not Mr. Pianowski.
All right. So you make an offer to purchase this house for a price. If people
Yes,
could
sir.
see this house, they would say, that's a lot of money, but that's a lot of house.
It is, yes, sir.
So, all right, you make an offer, I'll buy it. Mr. Pianowski accepts it in good faith. Then after you make the offer, you realize, hey, I can't keep horses on here. How is that a problem to Mr. Pianowski?
That is not an offer, or that is not a problem per se. These fall under our inspection provisions that were allowed during the contract period, to have further inspections done and find out zoning issues, which is even stated in the purchase agreement that we are allowed to have inspections for zoning purposes also, which I believe this would fall under. And then additionally, Your Honor, shortly after the revelation about the horses, it was noted that when we were looking at the GIS, the lot lines for the additional parcels that we were purchasing, the one identified as 5.91 acres, which is parcel number 04277707500, while it was listed as nearly the same amount of acreage as what the house was on, it was not close to being the same size lot lines. Therefore, I raised the questions, and we raised the question to our realtor, which in turn reached out to Mr. Nagy, and they confirmed that what we were getting was 13.49 acres. But what we were also told at that time was that in the summer of 2023, Mr. Pianowski had sold off 3 1-acre lots to other members of the community. And while those were reflected on the GIS as being now owned by other members, the acreage that was for that parcel number was not changed from the original 5.91. And so it was not actually 5.91 acres that lot therefore was. It was down to 2.68 acres. And if you were to view the GIS now, even though it says 5.91 acres in the tax description on GIS, it shows that it says now 2.68 plus or minus acres.
All right, so you
Actually
made a
lost
bid
3
on
acres.
what you thought was 5.91 acres, but he had sold off 3 1-acre parcels. So it was less than half of the lot size you thought it was.
Yes, Your Honor.
At this point, the acreage revelation detonates the deal. What looked like 5.91 acres shrinks to 2.68 after prior lot sales surface. Relying on county GIS, buyers suddenly face lost value. Legally, that discrepancy strengthens their right to cancel without forfeiting earnest money deposit.
And so then after we found that out, we had submitted an amendment to the contract agreement, asking Mr. Pianowski, because as I mentioned, we had based our offer off of roughly $10,000 per acre, that since the 3 acres was sold off and not known to us until after we were on contract, that he lower the asking price, or that we offer $30,000 less and ask him to accept $640 in light of the 3 acres not being there.
What was his response?
It was quickly denied, Your Honor. And on page 18 of the text messages that I have between myself and my realtor, and I'm pulling it up right now. It was said that spoke with other agent, and as I assume the seller is not interested in negotiating price at all. According to him, seller said 670,000 or deal is off.
All right. So at some point, the deal was off. At what point did you pull the pin and say, we don't wish to go forward?
Yes, Your Honor. So again, this was on 29 May that we had submitted this. Mr. Nagy had asked for it in writing, so we officially gave them that request on 30 May. Mr. Pianowski rejected it on 30 May. And by 1 June, we had signed the mutual agreement to release us from the contract. And then
You signed it. You signed it?
Correct, Your Honor. Signed it on 1 May and on 1 June. I apologize, 1 June of 2024. And on 2 June 2024, the house was listed and back on the market as available. And from that time,
Now you're out your $5,000 earnest money. You sued for $7,000. What's the additional $2,000?
yes, sir. So in addition to the $5,000, the $2,000 we are claiming for general non-economic damages stemming from emotional distress and mental anguish. Between the periods of July 2024 and March 2025, Emily and I reached out to Mr. Nagy no less than 12 times via phone calls and 8 text messages, on top of the times our agent reached out to him trying to rectify this situation. When we purchased our current home in Edwardsburg in July of this year, 2025, we had to make up the additional $5,000 through other measures of savings to cover the lost funds that.
Where did you actually end up purchasing a home?
I'm sorry, what was your question, Your Honor?
Where did you actually end up purchasing a home?
Edwardsburg.
Well, Edwardsburg's a nice town, but this was a very nice house for that price. And Centerville's a nice town with an excellent school district.
Yes, Your Honor.
Well, let's hear from Mr. Pianowski. They thought they could put horses there. They learned they couldn't. They thought they were buying a certain size parcel of property and they learned it was 3 acres less. You've countersued for $7,000. Plaintiff did not honor purchase agreement and it cost me 65 days of my house being off market. I lost my backup buyer. Your contention is it wasn't your problem to know whether horses were allowed to be on there or not. There's some commentary from the agents about whether horses were allowed or weren't allowed, and there was a talk about this variance or exception. To my knowledge, there never were horses on there, but that was after they made the offer. But his contention that the parcel wasn't as big as represented certainly does seem to have merit. What's your response?
Regarding the acreage, the acres were never listed in the original listing. The legal descriptions were, and my understanding is that it would be up to the buyer to ascertain what the acreages of those parcels were, the sum total of all of them. And but no representation was ever made by me or the written listing itself stating that there's any acreage amount whatsoever. I'm guessing here what part of the issue is that after I sold those other lots, that the acreages were never updated at the county level or the township, I'm not sure which you call that. But they may have been somehow misled by what the county has listed on their GIS. But at no time did I ever say how many acres there were. I was selling, the lots as described, as surveyed, and the price was the $670,000 total for the 3 lots.
Now the defense pushes back. Seller argues acreage was never promised and zoning checks were the buyer's responsibility. Horses were never advertised, he says, blaming outdated county records instead. But emails referencing a horse variance muddy that stance, raising credibility questions as the judge openly weighs fault versus fairness here.
So I don't really feel that I misrepresented anything. Everything is common knowledge. And with regard to the horses, if I may, horses were never advertised as being allowed on the original listing. I do believe at one point in the grand scheme of things here that my realtor asked me about horses. And I says, as a matter of fact, when I purchased the property, Almer furnished me with the variance, which I relied on when I negotiated the price with him. However, I never intended to have horses. I never did have horses. So it really was a moot point to me and I didn't really care, but I did retain that document. And I believe you have that document in front of you. Whether or not Doug Coolman rejected it or not, he never rejected it to me other than on the phone. And I asked him for his proof that he rejected it, and he failed to provide it to me. So I think that was on him.
There's an email on page 1 of, I think it's the plaintiff's claim. Just got off the phone with the seller. He is going to review all the purchase documents tonight and get them signed very soon. As far as horses, there is a variance for that property to allow horses. Seller's in the process of locating that document. It might come up in the title search, but I haven't seen it yet. And I know for a fact there's another that had chickens. Now this is his agent, not yours. But there was a discussion between his agent and your agent that there was a variance to allow horses. All right, this matter is really relatively straightforward. It's not worth $7,000 to the Bittners. You can't sue for emotional distress and non-economic damages in small claims court. You can sue in general civil court, but you can't in small claims. Small claims only about money damages. You sold the house, I believe, 26 days later, somewhere I read. Your pleading said 46, but I thought it was 26 days later it sold. And so earnest money, as you say, is to show that you have skin in the game, that you're willing to actually go for. This is a big purchase. This is a lot of money. Most people will never buy a house that is this expensive, but $5,000 is earnest money to show that they are willing to go through with it. There was a representation at some point that there was a variance for horses. But the other issue, whether it's your fault or their fault, it's maybe the city's fault, that if somebody were to look this up from the GIS, Governmental Information Systems, or I can't remember what it stands for, but which people regularly use to look at real estate parcels, it shows it was bigger than it was. They were buying 3 acres less. And I don't think that they would have known by doing the property descriptions on the property. They weren't ready to do actual deeds yet. So I think that's a legitimate reason for them to cancel this contract. They were buying 3 acres less than they thought. You weren't willing to compromise on those $10,000 an acre, so the deal collapsed. So Mr. Pianowski, I ordered you pay $5,000 plus court costs, or sign the release for the earnest money. As you said, you never actually got the money. I can't order you to sign the release. I could in general civil court, but not small claims. I order you to pay $5,000. And I'm sure you'd rather sign the release and give them their $5,000 back. Than pay $5,000 out of your pocket. I find $5,000 for the plaintiff. And $86.25. Defendant may sign release of earnest money I didn't spell earnest right. And then you would owe a total of $86.25.
And Your Honor, is that to cover our court costs for the filing?
Yes,
Copy. Thank you, sir.
the counterclaim is denied. It's time to release the $5,000 earnest money. The defendants acted in good faith. The horse issue was somewhat vague, but it would have led a buyer to believe that there was a variance that allowed horses, and they discovered that there wasn't. And that's part of the further zoning inspection. Hey, we thought we could get horses. We looked further into it and we can't. That's reason one. Reason two, they thought they were buying 3 more acres of land than they actually were by relying on the county GIS system. That's not your fault or their fault, but it's somebody's fault. And they're entitled to pull out of the contract. If you would have backed up $30,000, the deal would have gone through. I don't know what it actually ultimately sold for. So yes. Now, theoretically, this is due within 30 days. So in essence, you got 30 days to sign the release of the earnest money with your real estate agents. The money can be released to them. There's a new owner of the house. This is a bad chapter for everybody concerned. And they do get $86.25 for filing this claim to compel the return of the $5,000. All right, Mr. Pianowski, if you go out to the counter, you can get a copy of this, but that's my finding. They're entitled to their earnest money return, nothing more than that. There's no counterclaim. There's no showing that you lost X amount of money by selling this house 26 days later. I don't know what the actual sale price was. I guess I don't need to know. They get their earnest money back. All right, now if they don't, I'm sure he'll do it. He doesn't need to pay $5,000 out of his pocket. Well, all he needs to do is sign the release. He does still owe $86.25, but that has to happen within 30 days, or you can ask for a discovery subpoena to compel it. All right, Mr. Pianowski, if you go out to the counter, you can get a copy of that. We'll mail you a copy. I assume he'll sign it within 30 days and you'll get your earnest money back.
Thank you, Your Honor. And again,
Thank you.
may I address?
There's really nothing more to say. We'll just leave it for that. Hopefully you'll get your
Final outcome. The judge orders the $5,000 earnest money returned, plus $86.25 in costs, and denies the counterclaim entirely. Misleading GIS acreage and horse variance confusion justified cancellation. Seller gets 30 days to sign the release or pay. Like, comment, subscribe for stories.